What's up, everybody? Supreme Decisions here, and today I want to come to you. Thank you, Ashley, for donating for this episode. So that is our sponsor. And today I want to come to you with a question again that was asked, and it's regarding Frye hearings. What is it? Why is it? And where did it originate? The original Frye hearing is Frye v. U.S. 293-1923. Now, what makes this case relevant today, because I don't generally use cases beyond 1932, but what makes this case relevant today is a case that's discussing the admissibility of a polygraph test as evidence. In the case, Frye held that expert testimony must be based on scientific methods that are sufficiently established and accepted. The reason why they use those words, because again, if, and, or are the biggest words in law.
The law is the law, fixed, immutable, words with precise meanings, and that's good.
They will try to use things that's not accepted, that's still conjecture, versus actual things that are or can be proven to where it makes it relevant. This case, it was speaking about a polygraph test. Now, why Frye hearings? Because again, it's just like I spoke about with a police officer is doing an amicus brief when they're writing a citation, when they're filling out their police report, and they're coming to testify against you on behalf of the prosecution for a traffic citation. It is due to the steps of a Frye hearing from an amicus brief, because they are testifying as an expert on whatever the issue is at hand. Now, just on polygraphs, most people do not know there are only 12 states that use polygraphs as admissible evidence. And here's the funny part. Georgia isn't one of them. They will like to try, oh, well, would you take a polygraph and we'll do the... Nobody gives a shit because it's only used in 12 states. Those states are Alabama, of course, Arizona, California, Florida, Illinois, Kansas, Maryland, Minnesota, New Jersey, New York, Pennsylvania, and Washington, D.C., not state. So keep that in mind whenever you have someone that's talking to you and they're speaking kind of reckless and well, I'll hook you up to a polygraph. It means nothing. They can't use it. No need in even wasting your time in doing it. And again, it's just an intimidation tactic because they are not trying to solve a case. They're trying to get a case off the books. Keep that in mind. It's not about the truth. No one cares about the truth. All they care about is generating revenue. We all know they will do things that manipulate and lie to you to get revenue. So keep that in mind. When someone speaks of a Frye hearing, they're talking about scientific expert, but make sure you understand who the expert is, and you also understand the basis of what they're going to testify to, because that way whatever they testify to has to do what? Be sufficiently established and accepted. If it is something that's not accepted, if it's not the second part, it has to be officially established and accepted. If it's not both, the testimony is hearsay and can be thrown out. Because again, have to be a first-hand witness, even experts. Until next time.
Do not try and bend the spoon. That's impossible. Instead, only try to realize the truth.
What truth?
There is no spoon.
There is no spoon?
Then you'll see that it is not the spoon that bends, it is only yourself.